Good afternoon, everybody. Thank you for joining us for this Williams Institute webinar. We're going to talk this afternoon about sex offense civil commitment and LGBTQ and racial justice issue. I want to especially point out the second part of this title, an LGBTQ and racial justice issue, because I think this is one of those topics that tend to be more inconvenient for some in our communities to address. And so I think that we're going to point out the importance of this issue as a civil rights topic in general, but especially for LGBT communities and communities of color. We have a really wonderful panel, and I'm very excited to hear their presentations. We will start with Eric Janus. He's a professor of law at Mitchell Hamline School of Law, and he will give us a little bit of a brief, very brief, everything will be brief today, introduction to the topic to provide some context. Following that, Trevor Hoppe, who is an assistant professor at the University of North Carolina in Greensboro, will describe the research that he led and that we published, and a really fantastic resource of information, again, on a topic that is often very neglected in terms of discussing and understanding. And after that, we're extremely fortunate to be able to hear Nkechi Taifa, who is the founding principal and CEO of the Taifa Group. And she will discuss these issues and the context of racial and LGBTQ justice. I just wanted to point out one thing in terms of my own personal, how I got to this topic. I'm at the Williams Institute. My name is Ilan Meyer, and I'm a distinguished senior scholar here. And I started this by doing a study looking at incarcerated individuals in the United States in one of the really important data sets that became available due to the PREA law, which required the government to collect information on incarcerated individuals. And one of the most shocking findings there to me was not only the overrepresentation of LGBTQ people among those incarcerated, but also that they were more likely to be incarcerated due to what the data refer to as violent sexual offenses. And that struck me as really strange that LGBTQ people are offending so much in sexual arena, which is, to me, my area of work is stigma and prejudice, immediately brought up issues of justice, of over-policing, of over attention to what sexual and gender minorities do. And that finding, by the way, was true for both men and women. So both men and women were overrepresented among those incarcerated if they were LGBTQ, and they were there overwhelmed more so than straight cisgender people due to sexual violence offenses, quote unquote. And so that started a more probing into this area for me, and including leading to this interest in the registries and in civil commitment that we will talk about today. With that, after we will discuss these issues, we will turn it over to Tyrone Haley. Tyrone is Senior Policy Counsel at the National Center for Lesbian Rights, and he will help us in the discussion and question and answer. So if you have any questions, we would appreciate you entering them into the Q&A portion of this app at the bottom of your screen, and we will handle them. Of course, if there are a lot of questions, we might not be able to get to every single question, but we will definitely try to have a very good discussion of the issues. So with that, I'm going to turn it over to Eric Janus, and he has presentation, as I said, on the context. And after that, without further introductions, we will move through the rest of the presenters. So Eric, please share your slides, and looking forward to hear you.
Good. All right. Thank you so much, and thank you for having me. I'll just give us a short presentation here about sex offense civil commitment. This is something that I've been working on, I'm afraid to say, for 30 years now. I was very involved in the early 90s in challenging the constitutionality of Minnesota's law. And since then, I've continued to work on it in terms of publication and studying and advocacy. So this is something that a lot of people might not have heard about. What is sex offense civil commitment? Well, sex offense civil commitment is a set of programs that lock people up in secure facilities after they've served their sentences for sex offenses. This is a massive deprivation of liberty. It's like being in prison, but it's being in prison outside of the criminal justice system. In law, these are called regulatory laws, much like you might have laws regulating where nuclear waste is stored, and they're claimed not to be punishment. 20 states have these laws right now in the federal government. As I said, these laws lock people up after they've served their sentences for a sex offense in buildings that are called treatment centers, but look very much like prisons. This confinement is indefinite, and for many people, the only way out of this confinement is through death. Right now, there's about 6,000 people confined in these programs throughout the country. And the emphasis here is that these are pre-crime lockup programs. They lock people up based on predicted future crimes rather than as punishment for past crimes. Now, I mentioned that these laws lock people up in prison-like settings, but they're not called criminal laws, they're called civil laws. And as a result of that, the whole set of constitutional protections that we have about criminal laws is absent. So here's a list of the constitutional protections that attach anytime the state wants to take away somebody's liberty as a punishment for a crime. And here's that same list as it relates to civil commitment. As you can see, none of those protections applies to civil commitment. So you might ask, how can this kind of pre-crime imprisonment be constitutional in our system? It seems to turn our notions of constitutional protections upside down. Well, these laws, the constitutionality of these laws were litigated in the 90s up to the Supreme Court. And to summarize the legal issues that were involved, the states claimed that they were justified in locking people up in anticipation of a crime because these were just like standard mental health civil commitment. Just like they said the laws where people who are severely mentally ill are put in mental hospitals as a way of protecting them and others from injury that might occur because of a mental illness. Because these laws are kind of modeled then on this mental health civil commitment model, the laws require, in order to lock somebody up, a mental abnormality, a demonstration of a risk of future harm, and the provision of some form of treatment. And the Supreme Court then upheld these laws because they looked like civil commitment. They looked like mental health civil commitment. And the Supreme Court said civil commitment is one of the narrow categories that the Constitution allows for this kind of preventive detention. But there's very, very serious differences between sex offense civil commitment and regular mental health civil commitment. In standard civil commitment, the kind that is problematic but well established in the Constitution, there's almost always a severe psychiatrically defined and diagnosed mental illness. There's a severe impairment in cognition, in the ability to care for oneself, and the ability to make decisions, almost always some kind of psychotic illness. And those laws, those standard civil commitment laws, are aimed at harm that is imminent. Sex offense civil commitment, on the other hand, addresses a vaguely defined mental abnormality. It's very unclear what that means in these laws. A vaguely defined type of impairment, something called difficulty controlling behavior. And it's aimed at harm that is very, very distant, both in the past, because the last time these individuals did something harmful was before they served a prison sentence, and also in the future. There's no such thing as a requirement that harm be imminent in order for this kind of pre-crime detention to be allowed. Now, these laws, in my view, have multiple problems. They're extremely problematic. Number one, they're inconsistent with the basic rule of law principles in our country. These principles essentially say that we limit the ability of the state to take away people's liberties by constraining it by these great safeguards, all of those constitutional rights that I mentioned before. And yet this civil commitment, this sex offense civil commitment, does away with all of those protections. It's clear that this is an abuse of the mental health system. This is not a valid mental health intervention. It's not that sexual violence is not a mental health problem. And by characterizing it as a mental health problem, we distort psychiatry and also society's approach to the prevention of sexual violence. These so-called treatment centers are really gulags. People go in and they almost never come out. Now, there's some variation from state to state, but in many states, it's like a system of chutes and ladders. There's so-called treatment provided, but there's no clear pathway to be released. So for many people, it's a lifetime of detention. These laws are highly discretionary, yet they have the guise of science. They're based on expert diagnoses, but the categories that they use are very vague and ill-defined. And they're based fundamentally on the notion that we can predict human behavior, but we know that all of us, including experts, are notoriously bad at doing that, and that there are extremely high rates of false predictions. As a result of all of these things, these laws are highly susceptible to abuse and variation. We're going to talk about historically, during the first iteration of some of these laws in the 40s, 50s, and 60s, they were very, very clearly used against gay people. We're going to see today other evidence of abusive or biased use of these laws. And then there's very simple variations geographically from county to county within a state, high variations. Why? Because there's huge discretion built into these laws. They're not based on clear criteria. These laws build our sexual violence policy on a faulty set of premises. They're based on the notion that people who commit sexual violence can't control it. And yet that's clearly not the case. Sexual violence is a clear set of choices based on values, and these laws redirect our attention away from the root causes of sexual violence into this false notion that all we have to do is identify who's really dangerous, and we can separate them from our society like a cancer. And for that, that's a fundamental problem with these laws. And finally, just as a practical matter, these laws are extremely expensive, and they misdirect our prevention resources from approaches to prevention of sexual violence that actually have some promise to a system that is directed really in the wrong way. I want to mention that there's a couple of glimmers of light here. In Minnesota, very tragically, or I should say in Minnesota, there was some litigation about 5 years ago where the federal district court found the Minnesota scheme unconstitutional. That was reversed in the circuit court. More recently, a number of the inmates at the Minnesota program have begun a hunger strike, and that has caused the state to agree to have some negotiations with them about designing a clear pathway out of confinement. And in Virginia, we just saw a bill introduced in the Virginia legislature to abolish that state's civil commitment. Probably is not going to go anywhere, but it may be a start of a conversation that could lead to reform or hopefully abolition of these programs. So I'll turn it over to Trevor.
Thank you so much, Eric. That was really helpful and will help contextualize some of the findings I'm going to now talk about in the report that I authored alongside Ilan Meyer, Scott Diorio, Stefan Vogler, and Megan Armstrong. So shout out to my co-authors. It takes a village, and this certainly had a lot of people involved, and so I'm grateful for their support. So I'm going to talk a little bit about the research today, what we found at a very sort of big picture level. And obviously, if people want to go into more depth, feel free in the Q&A to ask questions or to email me or tweet me, get in touch, and I'm happy to talk more about the nitty gritty, because we'll be staying at the big picture level for this brief presentation. So we kind of had three basic questions that I'm going to talk about. And one is really basic, which is just how many people are in these programs. And that might seem like a superfluous or ridiculous question to have to ask. But because these programs are treated as medical facilities, a lot of times states do not release a lot of information about these programs because they say that they're covered by medical privacy laws. So just on a basic level, how many people are we talking about and where? Second, are people of color disproportionately civilly committed, demographically speaking? And third, are sexual minorities disproportionately civilly committed? And we'll talk about how we estimate that and what we found. Where did the data come from? Like I said, I'm going to just really stay at the superficial level, but if you want to get into the nitty gritty, please reach out. So three main sources of data. One was a series of Freedom of Information Act requests that we made over the course of about a year to every state that has one of these programs. Another is existing program survey findings that were already out circulating in the public, done by networks of providers of programs. And then finally, we had freelancers who scraped public sex offender registry data, and that helps us get at some of the questions of sexual minority status that we're going to talk about in a little bit. So those are the primary three main sets of data that we work with in this report that was put out last year through Williams Institute. Where are we talking about? I just want to sort of to put that up, that these are the 20 states that we're talking about when we talk about civil commitment. You can see pretty spread out through the United States. Eric mentioned Virginia, Minnesota. We'll look at also the number of cases in a bit, but just to give you a sense of where we're talking about. This is the map of the states. The federal government also has a separate program that's run out of a facility in North Carolina. All right, so the first piece of information, how many people are we talking about? We estimate that there are 6,351 people across 19 states in 2018. That does not include the federal government. They did not provide us with information on 2018. However, they did tell us that there were 49 people in 2019 in their facility. And it also does not include New Hampshire, which we only reported one case in 2017, but no cases in 2018. So a little over 6,000, and that was pretty consistent across the years that we looked at. The 5 states with the largest populations of detainees, some you might expect, others you might not. California having the largest number of sex offense civil commitment detainees, almost 1,000. Minnesota is next, and Minnesota is an interesting case because, you know, I think they have the 22nd largest population in the United States, and yet they're second here in civil commitment. So certainly Minnesota is an interesting case to look at more closely. About 740 cases there. Then Florida, 650 cases, Illinois, 560, and New Jersey, 476. So just because a state has a law doesn't mean that it uses it in the same way as every other state does. Some are more aggressive than others, and some have, the programs can look a little bit different, and more people might be released in some states versus others. To give you a sense of the size of that population mapped out, you can see here scaled representations of the populations across the United States. And I'm happy to share these slides if people are interested. Second question, are people of color overrepresented? The data for this question was only available in 12 states. And the reason for that is that many states simply code Hispanic or Latino people as white and in corrections data, and that overinflates white populations, since that makes it hard to estimate correctly rates of civil commitment in those states. So we only did this in the 12 states where we could accurately identify Hispanic or Latino populations. In 10 of the 12 states that we looked at, Black residents faced greater rates of civil commitment than whites. So that's the kind of takeaway finding. In almost every state we analyzed, there were greater rates of commitment among Black residents. Average rates on the whole, per 100,000 resident adults, we found that there were a rate of about nearly 8 per 100,000 for Black residents, and about 3 per 100,000 for white residents. Hispanic or Latino residents, lower, about 1.12. And again, we can get into some, if people are interested in the discussion about, you know, what's driving some of these disparities, we can talk about more. To look at Black to white ratios of rates. So what this shows is how much greater the rates were between Black and white residents in these states. So in Pennsylvania and Kansas, these are the two states where Blacks did not face a higher rates of civil commitment, so that number is less than 1. But every other state, it's greater than 1, and that means that there was an increased rate for Black residents. And the greatest disparity was in New Jersey, where Black residents had about a 5 times greater risk of civil commitment than in other states. And I think this addresses, for advocates in those states, to really think about how they can frame some of the discussions about what this program actually looks like on the ground and who's being impacted by these programs. Third, are men who have sex with men, and the reason I say men and not just sexual minorities is because 99.99% of people committed under these laws are identified by the state as male. Obviously, it's hard to address whether there are transgender people in these facilities because they are coded by the state as not as women. That question remains open, and we're not able to really assess it. But here what we see is that the state reports the vast majority of these cases. And when I say vast majority, I think I've only ever seen one case involving a female identified respondent. So almost all these cases involve men. So how do we get at sexuality? The state does not report this information. It doesn't report whether people identify as gay, straight, bisexual, etc. So we have to kind of infer it. And the way that we do that in that report, this report, is to look at victim gender for their underlying sex offenses. The crimes they were committed of in the past, what were the victim genders of those offenses? And we recognize that this is not a perfect way to do it, right? There is no solution here that would be perfect other than being able to ask every single person how they identify. That's not practical. So in Texas and New York, the sex offender registry reports victim gender data. And so we make that inference in those two states to look at rates of civil commitment between men with female victims and men who had any male victims. In New York, what we found was that about 1 in 3 of all civilly committed persons had male victims. So they were men who have sex with men, versus about 1 in 8 registered sex offenders. So you can see there's a big difference there. Something's going on that is driving a much higher proportion of people who are men who have sex with men to be civilly committed as compared to the public sex offender registry list. Texas, a remarkably similar pattern. About 1 in 3 of civilly committed persons are people who had been convicted of offenses with male victims. So men, we're inferring here that there are men who have sex with men. And that's compared to about 1 in 10 of registered sex offenders. So a slightly bigger difference in Texas between men with female victims and men with male victims. This was true. I just want to say we also look in the report of crossing race and sexuality, and not just race on its own, but also not just race on its own and sexuality on its own, but the two combined. And this difference between men who have sex with men and we'll just say heterosexual for ease of discussion respondents is pretty clear and evident in every single racial group. So for Black residents, there was a higher rate of civil commitment for men who have sex with men. That's also true for white men. That's also true for Hispanic men. So that sexual minority difference is true across all racial categories. This is New York State, you're seeing here, and Texas here. You can see again, similar patterns, but across all racial categories. So this isn't something that's just true for white or Black or Hispanic Latino folks. It's true across all categories. So just to summarize what I just sort of said, what's the gist? 6,000 plus people detained. Black men face disproportionately high rates of detention, and men who have sex with men of all races face disproportionately high rates of detention as compared to heterosexual folks. And from there, I will turn it over to Nkechi.
"44 years ago, I recited a poem as part of the African naming ceremony of the only born son of a dear friend of mine who is an educator and principal of a school. The baby's name was Mwando. I lost track of Mwando over the years until I found out he was in some type of trouble. My remembrances were that Mwando's arrest and conviction was whispered about in relatively hushed terms. Mwando was 26 when he was arrested in 1999. He is 44 today. He completed his time and was supposed to be released as a returning free citizen on December 4th, 2008, but was civilly committed and tagged with the label SVP, sexually violent predator. I'm thinking, Mwando? Nah, no way. And then I looked at the statistics and was quite surprised. This was not an issue confined to gay white men or even gay Black men. Black men in general were vastly overrepresented and were twice as likely as white men to be civilly committed and disproportionately detained in sex offense criminal commitment facilities. You see, sex offense civil commitment impacted not only males who have sex with males, but also males who have sex with females. The new sexually violent predator law in Virginia caused Mwando to be tagged with the scarlet letter label SVP and to be harnessed to Virginia indefinitely, despite the fact that his home is DC, despite the fact that he wants and needs to be close to his family. Indefinite means Virginia keeps him either conditionally released with unrealistic conditions or warehoused in jail or in the Virginia Center for Behavioral Rehabilitation, so-called treatment center, which is not even licensed as a hospital or rehab center, yet uses everything DOC, phone system, food service, etc. In the words of Brian Stevenson, I was proximate. I was proximate to Mwando's mother. I was proximate to his sister. I was proximate to his daughter. And I know that I am largely speaking to the choir of people who know far, far, far more about these issues than I, but there are likely a few who decided to tune in precisely because they saw my name, was curious to what I, an advocate usually vocal on criminal justice issues, would have to say. on issues normally reserved for gay and LGBTQ communities. When I first started working on criminal justice issues, we advocates, we were like baby stepping in terms of finding willing ears to even just listen to what we were saying. No one was talking about criminal justice reform, definitely no one political, not the Republicans, not the Democrats, both were in lockstep talking about throwing people in prison and throwing away the key. They were in lockstep talking about Black youth as super predators with no redeeming qualities. They were in lockstep on mandatory minimum sentences and 3 strikes. And we were trying our best to break that lockstep. I've worked in this area for over 30 years, but issues of people convicted of sex offenses was an issue that rarely rose to the forefront. And it was one that many advocates unintentionally swept under the rug. Now, I say unintentionally because the issue, much like that of violent offenders, was always there, but ones which we knew would gain no traction in a politically viable, a politically volatile environment. Indeed, we were barely making headway on the first-time nonviolent drug offender issue. However, today, with massive attention to the system of mass incarceration and talks of systemic change, there is an unprecedented opportunity to make certain that all elements are included and addressed as part of a comprehensive re-examination of a deteriorated criminal legal system where nearly half of the total US prison and jail population of over 2 million people is African American. It is a system of not just more stringent sentencing policies, but also these now new concepts such as pre-crime, where people are locked up prospectively, as we heard, on the presumption that they may commit a crime. It's most irrational and places us further out there on a shaky legal ledge. Just as there was no pharmacological science to the distinction between crack and powder cocaine sentences, an issue I worked on for almost 2 decades, there is no science to the concern labeled pre-crime. These laws are straight out of that movie Minority Report, where the state locks you up for what you might do in the future. In the US, lynchings and past Jim Crow justice aside, in the US has been a long history, a long tradition of punishing people only after they have been convicted. But these new Orwellian laws turn the rule of law upside down, condemning people for imaginary future crimes. It is, in essence, a constitutional and a human rights nightmare. Moreover, arguments of reliance on algorithmic measures are total non-starters, as the data often used reflects gross biases and simply entrenches racism. High-risk scores are often based on amount of education, employment, single parent home, substance abuse, community disorientation, prior criminal history, all factors which disproportionately impact Black people. Back in the day, y'all, law enforcement's the response of law enforcement to their overwhelming presence in Black communities would be because Miss Pearl, the elderly lady who lives on the corner, called them. Law enforcement would say that Miss Pearl didn't want to hear about long-term investigation. She didn't want to hear about science. She wanted us to get those guys off the corner. And I pondered, why did Miss Pearl not want to hear about effective ways to fight crime? Is it because the correct message had not reached her? Is it because she had been inundated and captivated by erroneous media depictions, and as a result, the media did not focus on it? She did not know about the consequence of law enforcement actions in her community? Likewise today, not only Ms. Pearl, but many criminal legal system advocates don't know that people can be locked up prospectively on the belief that they may commit a crime. They don't know what I only personally became knowledgeable about recently, the type of conditions Mwando has been subjected to, which the state claims are non-punitive. In essence, a shadow prison, okay, used in practice as a second and indefinite punishment. These people are essentially disappeared. Their presence and conditions invisible even to us advocates. Ms. Pearl doesn't know that Nwando and others similarly situated can get saddled with an emergency custody order for anything to be put back in jail for months, awaiting a hearing to see if they should be sent back to the VCBR conditionally released. Ms. Pearl does not know that the infractions include, but not limited to, traffic tickets, late for curfew, failed lie detector test, dirty urine, drinking a beer, accusation by anyone that he touched them, landlord arguments, going on any social media, job arguments, arrest with no conviction, arrest for a misdemeanor, the list goes on and on. They're not even allowed to help each other. A guy on conditional release was even reprimanded for attempting to send a friend in the VCBR a Christmas card and $20. Over the years of my advocacy, whenever changes or reforms finally came to any issues connected to the criminal legal system, there were always carve-outs for people convicted of violent offenses, as well as people convicted of sex offenses. And now, finally, 30 years later, advocates are slowly beginning to come up with narratives to negate, at least with respect to violent and nonviolent, that distinction. And the same needs to happen with sex offenses. It took 30 years for people to begin to feel comfortable outwardly advocating for release of people convicted of a violent offense. I don't think we can wait much longer to close the loop on all offenses. It's time to stop inadvertently or advertently throwing people and issues under the bus. For mass incarceration to end, all these issues, all of them, need to be brought to the fore. Low-hanging fruit as well as high-hanging fruit. We all come from the same human tree. We should be treated the same. If we don't do so, how can we ever expect legislators to? We must no longer have hierarchy amongst issues. I'm talking to my criminal justice legal system advocates that I work with every day. Mass incarceration must end once and for all, no matter what term, incarceration or shadow prisons or civil commitment, it is all the same, it must end. Now, I'm not saying that there should be no accountability, but the reality of the matter is that most people convicted of violent offenses have already spent decades behind bars. Most people convicted of sex offenses have already completed their sentences but are relegated to these nefarious shadow prisons. They can't just change the names and say it's not incarceration, and we must not allow them to do so. The issue of civil commitment must be viewed as part of the broader context of the expansion of the criminal legal system beyond prisons and jails. The issue of civil commitment must not be separate from what the criminal justice reform, transformation, and abolition communities advocate in support of. In conclusion, there is a broader conversation happening with advocates about ending mass incarceration that will never be resolved if the focus remains on nonviolent drug offenses, including changing our approach to violent crimes, changing our approach to sex offenses. A discussion of these issues in broad circles would never have been dreamed about and virtually unthinkable when Nwando went to prison in 1999, when the Republicans' long-time tough on crime mantra, parroted by the Democrats, fearful of being dubbed tough on crime, ratcheted up irrational sentencing laws. But today, it's a new day and a new narrative being formed. We need to raise the ante. We need to have the audacity to advance creative solutions for change. The Nwandos of our community, they are all crying out for us. Let us not fail them. Thank you.
Wow, thank you, Nkechi. You almost took me out with those words. I really appreciate the storytelling and really humanizing this issue. Again, my name is Tyrone Haley. I'm Senior Policy Counsel at the National Center for Lesbian Rights. I co-lead the LGBTQ sex offense policy subgroup, which is a part of the LGBTQ HIV criminal justice working group. And in working on these issues, I see how people who are charged and prosecuted for sex offenses are regularly dehumanized. in the civil commitment context, you literally see in statute people being called sexually violent predators. The actual dehumanization actually is in statute, similar to what we see in immigration, where we call immigrants aliens. And so Nkechi, you know, first of all, I just want to say thank you for your work and being in this fight to end mass incarceration when it was not a cool thing, when even Black leadership was calling on for locking people up and throwing away the key. And so you really inspire people like me who are really coming into this work and working on issues in which a lot of people don't feel comfortable. And so I'm wondering, kind of just on your remarks, if there are really lessons that you learned in, you know, in the decades in doing this work. You know, back when you were doing this work, as you were mentioning, young Black men would be calling like super predators, literally acting like we are monsters. And I remember growing up in the 80s and 90s and seeing images of Black young boys and men like myself, you know, basically as criminals and as dangerous people. And so I'm wondering, what did you see in the course of those decades? Like, how do we get to a process where literally people calling young Black men super predators, and now, as you mentioned, is like a very bipartisan issue? Like, what are some lessons, or how can we kind of move this issue to kind of help people to see, you know, those who are kind of pulled into the system as humans rather than being framed as monsters?
Absolutely. Thank you so very much, Tyrone, and thank you for your ever-present advocacy. You know, back in the day, believe it or not, we had to bring Black leadership kicking and screaming into the issue dealing with the disparity between crack and powder cocaine. These were the days when the only issue dealing with criminal justice that the NAACP was comfortable with was racism in the application of the death penalty. This was before the term racial profiling became a term of art. This was way back in the day, but it was strategic what we did. We had to educate our own people. We had to educate our own constituency, because if our own constituency wasn't standing up to this issue, it was going to be hard to bring in other constituency. So we started there. And today, fast forward, you know, decades later, you might think, what are you talking about, Nkechi? How can that be? Well, those were the days when, again, both Democrats and Republicans were voting for the crime bill in 1994. Okay, which really led to all of this mass incarceration. So it took a lot of education, and it was a protracted struggle. What I'm saying now, it should not have to take another 30 years for this issue now. We made some mistakes back then. We did make mistakes, I feel, even though at that time it was the only way we felt that we could get traction was to deal with the issue of first-time nonviolent drug offenders, but we essentially ended up painting ourselves in a corner. And it's been so hard to draw ourselves out of that corner when we look at all of the other constituencies out there who were not first-time, who were not drug offenders, who were not nonviolent, okay? And now we're talking about sex offenses, which in many cases is more of a priority to certain people than violent offenses. We need to change that paradigm. The system treats us all unfairly, and we need to combine together in order to fight it. It can be done. We did it in the past. We just don't want to wait another 30 years for it to happen. We all need to just unite and step up to the plate. So thank you for inviting me here to the forum. As Brian Stevens said, it really is all about proximity. So I'm hoping that my proximity makes it so that other people don't have to be proximate in that way. You can just look at the issue. You don't have to know somebody who was in the situation. So anyway, that's it.
Thank you, Nkechi. That was very helpful. I think it's always really important to learn from history, because as Abba says, you know, if it's sitting on a shelf, it's going to repeat again. So Eric, I want to talk a little bit more about these so-called treatment facilities. You mentioned a little bit that, you know, basically like a black box, people go in and never come out. I mean, you hear treatment facilities, so it's like, what, they're doing yoga, having group therapy sessions. Like, what do we know is actually going on in these facilities, and what do we not know what's going on in these facilities?
Well, you know, first of all, there's something called treatment in all of them, and there's some variability, I think, across the country. And I think in some places, there's probably a serious effort. In other places, treatment is a fig leaf, just covering up. It's definitely a secondary thought and thought to be necessary to make these things constitutional. And what's for sure, and what we know from a lot of the litigation, particularly in Minnesota, is that the treatment program can be manipulated in a way so that people don't progress through it, and no one gets out. So is there such a thing as treatment for people who've engaged in sexual violence? Absolutely. Is it beneficial for some people? Absolutely. But is it being done effectively in these programs? I can't speak for every one of them, but for a lot of what I know about, the answer is no, it's being manipulated.
Great, thank you, Eric. That's very helpful. Trevor, so I know in your work you study how anti-LGBT bias shows up in criminal law. And I'm wondering how in this specific area around sex offense civil commitment, do we see this also happening?
Thanks, Tyrone. That's a great question that I didn't have time to talk about, so I'm glad to address it, because in the chat, there was also some discussion about it, I noticed. So we found, right, that there seems to be this overrepresentation of men who have sex with men, or men who were convicted of crimes with male victims, as compared to men convicted with female victims. And so what's driving that disparity? Where does it come from? Because it doesn't just fall out of a tree, right? There's something going on that's driving it. And all we can do in the report is see that these differences exist. We need to do more research to really understand what's driving them. But one thing that we identify in the report that is a possible driver is that in many states, they use tools, evaluation tools, to determine whether someone is a good candidate for civil commitment, called Static 99 or other sort of static instruments. There are revised versions, but these are like a series of questions about the person's criminal record and life and offense record. And one of the items in that evaluation instrument is asking whether the person had any male victims. And if you had a male victim, that automatically increases your score. You're automatically determined to be at a greater risk. And to be therefore to be more likely to be viewed as a good candidate for civil commitment. So there is a instrument that directly, sexuality is directly built in there, that is used to categorize MSM, gay, bisexual, other men who have sex with men, as necessarily more dangerous. And I think that's one thing that we ought to advocates ought to really latch onto to better understand what's going on here, to really explore how that instrument could be driving disparities.
Thank you, Trevor. I think it's really important to talk about that, because in my work at the National Center for Lesbian Rights, we see that LGBT people are more likely to be in the criminal legal system. And so that criminal justice reform is really important, not only in terms of racial justice purposes, but also in terms of LGBTQ justice as well. So thank you for highlighting that point. So one of the questions that came up is that, when these statutes were starting to be passed around the country, that only as we in the map, only certain states decided to go down this path. And does anyone have a sense of why certain states decided to do this and other states decided not to go this route? There's like in a sense of what was behind that. Maybe that's unclear, but just want to put that and see if you have thoughts, Eric.
Yeah, well, one key reason is the expense. These are very expensive programs. And following, there were a couple of surges, a couple of panics, where a bunch of states, and actually a number of the first states were progressive states. So Minnesota, Washington, Wisconsin, Massachusetts. But after that, it kind of died out, and then states began to understand what a massive commitment of resources was required. And I think that the last state to pass this was New York. And it was actually a fairly long, drawn out fight there. And resources was a lot of the issue.
And I just want to add on to that, to what Eric said there, is one of the really fascinating things when you look at the trends of where these cases are, is it's not for some people, it might be surprising that it's a lot of blue states, right? It's not the places you might expect. It's the Minnesotas, the Californias, the New Yorks of the world, these kind of stalwart blue states. And as a sociologist, that also gets me thinking, like, what is it about sort of liberal politics that attracts them to this option, even though it seems to be so deeply punitive, so much more punitive than criminal incarceration? And I think for liberals, it has the appeal of medicine, and that therapeutic element, I would argue, it has that appeal to them, whereas you know, conventional modes of punishment seem outdated, I think, to some on the left. That's just, you know, I think as I'm looking through and trying to understand these trends, that's one thing that I think people advocating around this issue want to think carefully about, because it's not just a left versus right issue in the way that you might expect.
Ilan?
Yeah, I just wanted to add one thing, because when we talk about the labels of violent sexual predator or the words that are used, when you actually begin to look at those tools that Trevor mentioned, that assess risk, that qualifies a person to this really horrendous punishment, post-punishment, as Eric mentioned, those risk assessments are basically actuarial tables. This is kind of the same thing that maybe insurance companies use. And they might have some value in kind of general population level understanding the way that insurance companies use them. But in addition to what Nkechi mentioned, they're based on research that is flawed already, because they have to use some research to begin to build those tables. And then those tables are used in a way that applies to a person. So when you hear this person was designated as a sexually violent predator, you're assuming that somebody sat there and analyzed this person's behavior, and based on knowledge and some kind of ability to read into the future, they're able to tell you that this person is very dangerous. But in fact, it's none of this. Even at the level that they identify risk, some of them, the risk is really minimal for reoffending. And that already classified, like a 20% risk, a 15% risk, that's considered high risk. And that classify you as a violent sexual offender, as a potential to re-offend. So I think the labels that are used, and we have to use them too, because that's what the law uses, they already bias us to think about this group of people as very dangerous people. And we have to keep our critical eye on this language, because that is often not the case. And another thing that Nkechi mentioned, some of the violations that lead you to this are parole violations, are failing to register in some way on time, where registering itself is so difficult and so many obstacles in the way. So we have to be really critical. We're not here saying dangerous people should be let go of prisons. We're saying here, these are people who the label of dangerousness is questionable, and they already served their time, right? So there's something that I think any human being can understand in a kind of civil rights level, in a basic human level, is very wrong.
Thank you, Ilan. I have one last question from an attendee. There's a question on, are there any state or federal bills to address this issue of civil commitment? Eric, I know you mentioned the bill in Virginia, which I know someone mentioned from Just Futures Project who's working on this issue, but I just want to give you an opportunity to talk about the Virginia bill or any other bills that you may be familiar with.
Yeah, I'm not actually familiar with anything else around the country. It's not the most attractive issue for politicians. And it's one of those things that once they get this law on the books, no one wants to touch it, even to reform it. So the Virginia initiative is the only one I'm aware of, and then this recent nascent initiative in Minnesota.
Thank you, Eric. We're coming to a close, but I just want to say thank you for everyone who attended this panel. And I really want to thank Eric, Ilan, Nkechi, and Trevor for participating. You know, Trevor for really kicking us off in terms of like bringing this issue to us in the first place in terms of from a research perspective. I just want to say, as someone who works at a national LGBT organization that sees itself as a feminist and also an organization that is really committed to racial and economic justice, that this issue is something that we do need to be talking about, and we cannot shy away from it, as Nkechi really in a powerful word to really remind us why we can't be doing that. And so again, thank you all for joining us today for today's discussion. This won't be the only one, so look out for other ones. And I'm going to turn over to Ilan to close us out. Thank you. Oh, we can't hear you, Ilan.
Sorry, thanks. Thank you, Tyrone, and thank you, everyone. And thanks for the people who commented with challenging and interesting comments and questions. There's definitely complex issues, and we appreciate the opportunity to be able to think about it and talk about it, and hopefully do something about it as we move forward in our own circles. I just wanted to let you know that this presentation was taped and it will be posted shortly on our website and our YouTube channel, but also is available on Facebook. If you follow the chat, Rachel, our communications director, has been posting a lot of really great links. And I'm thinking maybe we will add some of them to the Facebook presentation if possible, so that people can have them for reference later. So with that, again, thank you everybody, and thank you for this stimulating panel. And I hope you join us soon when we talk about issues related to criminal justice again in the near future. Thank you.